Alex here with a legal nuts and bolts video on power of attorney. I really didn't want to cover this topic, but I'm starting to get a lot of questions on it with respect to guardianship because I did a video on guardianship a while ago. The difference between power of attorney and guardianship is pretty big. Guardianship is imposed on someone by a court against their will, and it's based on the person being declared incompetent. And of course, the court will give the decision-making authority as to that person and their finances, usually both, to a guardian, and that person will become a ward. I don't think they call them that anymore. Now they call them a protected person. Same thing, different name, doesn't sound as bad, I guess. Um, with regards to power of attorney, the person who is assigning decision-making powers is not a court. It's actually the person who wants somebody else to help them make decisions. Usually out of convenience, just because they don't feel like doing it themselves, or they're maybe just too busy. This person's not incompetent at all. They're perfectly competent. They are just they're just delegating their rights to make decisions in certain areas to another person. And one of the big differences right then and there is that to end a guardianship, a judge has to terminate the guardianship, and it takes effort. It usually takes litigation, not always, but usually the protected person, or maybe somebody else acting in their interests, tries to terminate the guardianship, and the judge has to approve it and enter an order. With the power of attorney, the person's perfectly competent. They gave somebody else power of attorney, and just like that, they can take it away. It's not really a court thing. It's not done through the court process. It's just done in writing, and usually there's rules in place as to how it has to be done. It may have to be notarized, and there may have to be other specifics in the power of attorney for it to be recognized. I guess the last thing I wanted to mention is that it's usually used at like maybe banks, so that people can handle finances on an account without actually having to go. Whoever it is they gave power of attorney to can go for them and do it. Also, maybe like the DMV, possibly the DMV. I don't know for sure. I've never used one of these, but maybe like an actor or an actress wouldn't want to go waste their time at the DMV to like register their car. So maybe they can give power of attorney to somebody and have them go and do it for them. There's also something about medical decisions. It probably makes a lot of sense that this is done before a person is injured, while they're perfectly healthy and perfectly able to make decisions for themselves. The power of attorney can be done to have some other person, friend or family member, be designated as to when to make their medical decisions for them. It may not necessarily get recognized if the hospital doesn't get like a copy of it, or if the hospital just doesn't even know that there's an attorney in fact out there. I should probably mention what that is. So when a lawyer is representing you in court, that's an attorney at law. When you give power of attorney to some other person, that's an attorney in fact. I'm not sure where those terms come from, but anyway, what I was mentioning is there may be situations where, like in that kind of situation with the hospital, that the hospital just doesn't even know there is an attorney in fact, and so they just don't. That happens sometimes. So it's important that the person who has power of attorney, find out that you're injured and go and make decisions for you. I guess the last thing I wanted to mention I guess I'll mention two more things when it comes to power of attorney. The first one is that a person who's incompetent shouldn't be asked to sign a power of attorney. Like, you shouldn't go to somebody who's had like a brain injury and tell them, sign this piece of paper so I can make these decisions for you. Because my understanding is that that's the same thing as asking a person who's had a brain injury to like sign a contract. It's not allowed. They're mentally incapacitated, assuming, depending on the trauma that's happened to their brain. If they're not able to sign like agreements for, I don't know, like a cell phone or to buy a house or a car, they're obviously not competent to sign a power of attorney. I don't know why this comes up sometimes, but I've heard stories that, like, I don't know, caseworkers at hospitals suggesting that, oh, just get them to sign the power of attorney so you can make decisions for them. That's weird. If a person's been mentally incapacitated and there's no power of attorney in place, you should probably do it the right way through the court system and get a guardianship imposed. I hope that these examples aren't occurring all over the place. I hope it's just isolated incidents. The other thing I was going to mention was that I think possibly a power of attorney can be used in a guardianship case if it was prepared before the person was mentally incapacitated as a sort of hint or clue or preference to the judge in the guardianship case. So like say somebody gave power of attorney to somebody when they were perfectly fine and then they got in like a car accident and hurt their brain, and now they're incapacitated. From what I've looked at, it seems that the fact that somebody was given power of attorney when they were competent is weighed heavily in the guardianship case with respect to choosing their guardian. Now that's if they find out that a power of attorney even exists. Again, same problem could happen where there may be a power of attorney out there and just nobody even knows, and so the court doesn't know because it's not brought to their attention. Um, Sort of as a side note, it seems to me that power of attorneys would be valid um, if they were created at a time when a person was competent. So like, it seems to me that if somebody has the power to, um, I don't know, access bank accounts or register vehicles at the DMV and make medical decisions because somebody gave them power of attorney when they were perfectly fine and then they injured themselves and they ended up incapacitated in the hospital. Technically, the power of attorneys, it's not invalid. I mean, it probably wouldn't be rescinded because the person's incapacitated, but it seems that that person would continue to be able to manage their affairs, at least for a time. There could potentially be somebody else that comes out and petitions the court for guardianship and sort of strips the power of attorney, or sort of strips the attorney, in fact, of any power at that court case. But perhaps up until that time, something like that would be still in effect, and whoever has power of attorney would, at least for a while, be able to take care of that injured person. I hope that I covered everything that I could. I honestly have never used one of these before, but I did get a lot of questions on it, mainly from people who watched that guardianship video. In all kinds of different contexts, I got questions on it. So at this time, if anyone has any questions on power of attorney, feel free to post in the comments below or send an email, and I will see you guys next time.